Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on the estate tax and AB trusts. Now, the estate tax is a federal tax that applies to large estates at death and taxes a certain portion above an exemption amount, an amount that you're able to pass tax-free. Now, for many years, that estate tax exemption was so small that most people had to have some concern about the estate tax applying. And therefore, a lot of estate planning dealt with that. In our modern times, the estate tax exemption has increased to such a large level that very few people have any need or concern to plan around the estate tax. But because many of us have put estate plans together some time ago and maybe haven't looked at them for a long time, many of us may have planning in our trusts that is no longer very useful to us. All going back to this estate tax avoidance and AB planning. So I want to talk about that a little bit and go into what an AB trust is, why it's useful, and why it may not be useful for your estate now, given the changes in the tax laws. Now, in the first place, an AB trust, the reason we call it an AB trust is because it was designed to divide at death into two trusts. And that is for a husband and wife who have a joint trust together, when the first spouse dies, that the assets of that joint trust are going to go from being a single trust to dividing into two separate trusts. Now, the idea behind that was, now, when the first spouse passes away, they can give all of their property over to the survivor. The survivor can take everything, and they're not going to have any estate tax diminish the assets that they have left to care for themselves. They'll still have everything. That's called a marital deduction, the unlimited marital deduction. They don't have to worry about that. But when they pass away, eventually, then they're only going to have their exemption applied to the entire estate. And therefore, for the next generation, they're going to have more of that property taxed before it goes to that next generation, because they only have one exemption applied. So that's what AB trusts were designed to do, was divide that trust into two trusts and create one trust that was irrevocable, that contained all of the property belonging to the deceased spouse that was exempt for estate tax purposes. So they basically just put everything in this basket over here. So this is my exemption. I'm using it now. This property does not go into the estate of the surviving spouse. What that means, everything else then could go to the surviving spouse. They could have full control over that. They can make changes to the trust, and they can care for themselves. That trust over here, that B trust, the deceased spouse's property, could still be available to them for any needs that they might have, but otherwise it would stay there and use up that exemption. Then when the spouse passed away over here, they would have their exemption apply to that. Both exemptions were used. They could pass out the maximum to the next generation. What's happened is we now have an exemption that is over nearly 12 million per spouse. And so there are very few people who have any interest or need for that trust to divide into two halves. And therefore, if you have a trust that's been set up long enough ago that divides into an AB mandatory split at the death of the first spouse, you have a surviving spouse who now has two trusts they have to manage. They have different tax ID over here for this trust, different rules for how it operates, and they have to manage both of these things, perhaps to take care of what may be modest needs. So because of that, it can be very cumbersome if it hasn't been updated to have this AB split, where most surviving spouses are probably not interested in that. And because the estate tax exemption is so high, there's no benefit to be realized for that. Now, there are some other benefits besides tax purposes for having an AB split. I'm not going to go into those right now. For most people dealing with an estate tax specifically problem alone, the AB split for most of us is not going to be necessary. And if the idea of managing two different trusts or having your property divided into two different equal shares is not attractive to you like it is unattractive to most of us, then you don't necessarily want that AB split. Even for people who have large estates where estate tax is possibly an issue, there are other ways that we can deal with some flexibility to ensure that they can maximize both estate tax exemptions In addition to the fact that we have portability laws that allow a surviving spouse to basically secure the use of their deceased spouse's estate tax exemption at their death and use it and apply to the surviving spouse's estate when they pass away. And so because they can use both estates, no need for that AB split. If your trust does that, it provides for an automatic mandatory AB split. It may not be what you want. It may be cumbersome for the surviving spouse, and it may be much easier to change that now than it will be to deal with it upon death of the survivor, of the first spouse. If you think your trust might have this provision in there, if you want to see about this AB trust and see if some of the other reasons for using them are useful to you, give us a call and come in and see us at Stone Law Offices. We'd be happy to help. Thanks.